Crown prosecutor. Andrew, thank you very much for Andrew Barbacki is a criminal defense lawyer and former Crown prosecutor. Andrew, thank you very much for joining us.
It's my pleasure.
People are going to hear about these charges being stayed, and they're going to wonder what happened.
Well, there's actually seems to have been two main issues. There's a question of the delays with the Jordan ruling from the Supreme Court last summer. There's also a question of the method used to access encrypted messages between smartphones. And previous to this case, there was a motion pending where there was a request by defense to have the court order the RCMP effectively to disclose what method they used to get at these private conversations in order to be able to check the legality of the interceptions. And they declined to do that and actually stayed another case. So in this case, that was an issue as well. So it's not really possible to know exactly what was the main issue or why, but those were two issues which motivated the decision, apparently.
You know, it almost sounds like the investigators did something wrong.
Well, not necessarily. It could very well be that this method is being used perhaps in a big investigation right now. You might read in 6 months or hear in 6 months that there was an even bigger bust based on the same technology. Apparently there's a program, I think it's called MDI or MMC, something like this, there's an acronym for it, and it's some special tool used to get at encrypted messages. So it could very well be that it was to protect an ongoing investigative method which could be used in the future.
What role did the Supreme Court decision play in all of this? I mean, that decision essentially said, hey, hurry up and get to trial.
Right. But, you know, the reason why I wonder a little bit whether that was the only decision or the main factor is because there didn't seem to have been an attempt made by the Crown to bring the case to trial particularly quickly. In big sweeps like this, they often use what's called a preferred indictment, where they skip the preliminary inquiry and they schedule a trial before jury or even a judge alone, but get the case directly to trial. They don't seem to have done that, so I'm not sure. It was probably a factor. And one of the problems is when you have a big sweep like this, the volume of evidence is so vast that it's very difficult to organize it, to weed out what's relevant, provided to the defense. And often it's subsequent to the arrest that a lot of legwork, if you wish, is being done by the police in order to transcribe conversations, to translate them, to put them onto a usable electronic format. All of this requires a lot of manpower and a lot of effort. And in cases, I suppose in this case, it might have been foreseen that it wasn't possible to get it done within the time constraints. But the prosecutions are continuing against some of the people arrested. I think there's 12 persons, if I recall, where the cases are still going to proceed. So it's not a blanket withdrawal of everybody.
You know, Operation Clemenza was within the last 3 years. It wasn't 10 years ago. How much time has the Supreme Court said is reasonable?
Well, they put down a pretty solid guideline of 30 months for cases in what's called Superior Court, which are the more serious cases. That covers pretty much all the serious cases. They put a ceiling of 30 months. Beyond that, there has to be a good explanation, but it's not an absolute ceiling. However, there are a lot of cases in the system right now prior to the ruling, which are a lot more than 30 months. And as you say, in this case here, it could have been foreseen by the Crown that there's no way that they could get it to trial in a reasonable amount of time. And they were not perhaps able to justify some of the delays. But I would imagine in the future, they'll adapt some way or the other, I would think. It sounds a little bit too good to be true for organized crime that major investigations are just finished because of the Supreme Court ruling in Jordan, and the case is named Jordan. So I would imagine that there will be steps taken to remedy the situation for future investigations.
Andrew, some groups have the wherewithal to hire the best lawyers, the most expensive ones. Does this provide them with an opening to sort of take advantage of the law?
Frankly, I think it's the defense lawyer's job in every case to see what the possibilities are. After all, we're not judges. We're not paid to interview clients and make up our minds whether they're guilty or not. It's our job to present the best case possible. And if there are what's called loopholes or technicalities, whatever the public wishes to call them, that's basically what we do in every case, whether it be an organized crime case, a drug case, a violence case, a fraud case, whatever it is. It's our job to see whether we can find a way to have the client avoid the consequences of being found guilty.
Criminal defense lawyer and former Crown prosecutor Andrew Barbacki. Andrew, thank you very much.
You're very welcome. It's always enjoyable.